Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. Reddy Neumann proceedings and immigration updates. Emily, right now things are like chaotic in the immigration field. There are so many new developments. It's becoming tough for us, for me at least, to catch up with the things. One is that the premium processing fees went up. The DOL regulations came in with a prevailing wage starting from October 8th. Then we have these interim regulations that are starting in October, that were published in October, but they are going into effect in December. We have this downgrade thing going on of the EB2 to EB3, and then there is some mailroom chaos going on in there. What's going on? I mean, what is it created intentionally to harass the immigrants, or is it like? What do you think of it?
Well, I think definitely anything that's happened from a regulation standpoint and from a presidential proclamation standpoint is certainly meant to make immigration harder, to restrict immigration, to keep building that wall, even to block legal immigration. All of these other things going on with the change in the premium processing fee, that was actually done by Congress. So that was a law that was passed, which was actually meant more to ease the budget issues that USCIS has been having. But all of these regulations, those have certainly been targeted to reducing legal immigration.
So, Emily, now the elections are in the horizon. We know that the increased participation in the second largest democratic country in the world, which used to have a very low polling rates compared to like the biggest democratic country like India, where the polling rates are about 80% sometimes. Though polling rates are about 50% now. It looks like people are enthusiastic about voting. Whether they stand this side or that side, they're very enthusiastic on standing. Now, there are mixed feelings for the Indian nationals on, in one way, the Trump administration is putting restrictions. The other way is that, well, I'm getting benefit because my priority date is moving faster because he's blocking up all the people who are coming outside the country. What do you think of these elections will hold? Which way? Does it have any impact? If, let's say, for example, if the Republicans win or the Democrats win, which way are we going?
Yeah, I think, if the Republicans win, if Trump wins, we can see more of the same, more restrictions coming in, more different ways of going about the regulations to try to sidetrack the normal process and go straight to these final rules, more litigation, trying to block all of these changes that they're trying to do. If it goes the other way and we end up with Biden winning, I think that the difficulty there is it's going to take him time to undo everything. I think the first thing that he can undo is the presidential proclamation, so maybe the H&L travel ban, the immigrant visa ban, those kind of things might go away relatively quickly, but everything else that the Trump administration done has been done by regulation, which means you have to go through the regulatory process to eliminate it. So that is not going to be a fast process. So just because Biden wins, it's not going to mean everything goes back to the way it was before Trump.
What about these immigrant visas, Emily? I mean, because Trump blocked the immigrant visas coming from outside, the Indians are able to get the benefit in the 2021 year starting from October 1st. Can Biden now put those things back into the family immigrants?
I don't think so, because that is, an operation of the statute, the law that's passed by Congress. So I don't think a president has the power.
The president has the authority to give those numbers back to the family immigrants, unless the Congress acts. And there is no, the probability of Senate passing this bill seems to be very nil. Even if the new Senate comes in January of 2021, remember that even though elections happen on November 3rd, the new government is going to come into power in January 2nd, right? January 2nd of 2021. And as Emily pointed out, though, to give the numbers back, it requires that it has to go through the Congress, the Parliament. Here in USA we call it as Congress. It has to go to the Parliament. The problem there is, or the advantage there also in a sense, is that It requires mostly, because if any senator objects, it requires 60 votes out of the 100 in the Senate. At this point of time, nobody is predicting to have one party to have 60 votes in Senate. Nobody is predicting. I've seen all polls, so nobody is predicting that it's going to be. So anything to pass through the Congress or the Parliament, it's very unlikely unless everybody agrees to the terms, which mostly, for example, giving the business immigration visa that were already given to them, putting it back to the family immigration, is very unlikely even if Biden comes in. So people don't have to fear that if Biden comes in, that it's going to come back. What he can probably do, Biden, is that to cancel the presidential proclamation. Going forward, though, he may issue the family immigration and the business immigration that are coming from outside. He may take the ban out, so those numbers may not roll every year. But what do you think?
Yeah, I think that definitely the presidential proclamations would be the first order of business in terms of eliminating those if Biden wins. From there, I think a lot of what he'll focus on is more DACA and the undocumented population and TPS and all of those changes that have been happening. I think that's going to be the first priority, which means employment-based changes going back to where they were or being updated and modified are going to take you
all
longer.
Those what you're speaking doesn't even require regulations. A presidential proclamation will do the job, though. That will be the first target for Biden. And the next will be going to the regulations and then probably going to Congress, which, Congress hasn't passed any major legislation in the past 30 years on immigration anyway.
Right. Yeah, and the other major thing we have going on is all these lawsuits. It seems like every time the Trump administration does something, a lawsuit is filed. So the most recently we have the interim final rule that drastically changed the way the Department of Labor calculates prevailing wage levels. And that took effect from October 8th. And in reality, it was actually retroactive because it applied to prevailing wage requests for perm cases that were already submitted and pending. So starting last week, we started getting those prevailing wage determinations, and 5 months ago when we submitted them knowing that we would expect to get a certain wage, and now all of a sudden it comes back at a completely different wage. So we have at least 3 lawsuits filed already. And the most recent one included a preliminary injunction, or that's about to be filed today, I believe. All of them are expected to file a preliminary injunction. So what that does is, before the court actually gets to the merits of the case to decide it, they're arguing that we're so likely to win on this case that you need to block it from taking effect. And in one of the preliminary injunctions, they're basically, if they win that, they're asking the court to go back and tell the Labor Department to reissue those prevailing wages that have been issued over the last week or two. That is up to the judge to decide, so they have to find first that the groups that brought the lawsuit are likely to win when they actually get to the merits, and then they have to decide if that's the type of relief that the court has the power to grant. And then once that injunction takes place, the court still has to actually decide the case. So the actual litigation could take months, if not longer, but that will at least provide people some relief in the meantime if the preliminary injunction is put in place.
Some of the organizations that joined is some of the universities that joined the court litigation against the Trump administration, and also the National Manufacturing Association also filed its own case against Trump administration to not implement these new changes. So hopefully some things may work out. Seems that most of the time the Trump administration is losing the cases, and the way that the prevailing wages were being increased seems to be completely not legal, according to me. It doesn't meet any of the realistic market conditions. So there is a good chance that we may get a preliminary injunction on that. Emily, on the premium processing increase, now, boom, all of a sudden we are charging, $1,000 more Does it mean that they're going to cut down the time and implement the premium processing much better, or the time is going to increase?
No, unfortunately, it doesn't provide us any benefit or new service. It's just to continue the status quo. So starting from yesterday, any premium processing upgrade or filing for I-129s or I-140s is now $2,500. This does not have to do with the regulation that was planning to increase filing fees. That regulation was going to increase the processing time of premium processing to 15 business days instead of 15 calendar days. This is separate from that. So this is a statute
So that
passed
one
by
was supposed to be
Congress.
going into effect on October 2nd, and the court did an preliminary injunction to it. And then these people came out and is there a chance that if we go to court, we may win on this one too?
This one is a different story because it was passed by Congress. You have to, in order to win in court, you have to prove that Congress was not authorized to pass this law. Or
That's going to
the
be tough.
Constitution did not give them the power, which is not really the case. I don't think there's anything that can be done about this particular fee increase. But it is also not related to the H4 EAD premium processing idea and the I-140 EB1C premium processing. That was also passed by Congress, but they gave the power to Homeland Security and said you can implement this through regulation. They have not started any of that regulatory process, so I don't expect the I-140 EB1C or the H4 EAD to have its own premium processing in the near future because they have to go through regulation.
One thing, that idea that struck, I made a statement that no major immigration bill has passed the Congress from past 30 years. Now, then you're saying that, okay, the fees increase bill was just passed in the parliament. And what about the Senate 386 bill? Why is so difference between the Senate 386 bill and this premium processing bill? I mean, why can't it pass the same way that it passed the premium processing bill?
Yeah, I mean, the premium processing was actually part of a whole spending bill that was meant to continue to fund the government as a whole and also to deal with USCIS's budget problems. So, I think that it's easier to slip in some small legislation in a much larger funding bill, which is what happened with the premium processing bill, compared to a standalone one bill that there's just a lot
targets immigrants.
Yeah, exactly. That's real hard to get passed when it's, especially immigration is, a hot topic right now. Lots of people have strong opinions one way or another on it.
Any prediction? Today we are at October 20th, Emily. We used to get the visa bulletin in 9th and 10th of the month. Last month it took until 24th of the month. Any prediction when it's going to come? What's in the pipeline there?
I'm really hoping by Friday, which would be the 23rd, I
Okay.
think. It might not even be until Monday. It's just later and later. As far as predictions, I think the filing date chart should remain the same as it is now. The final action dates might move forward slightly.
So having said that, we know that the final action dates, especially for EB2, are going to move. But what it is really for the Indian nationals is the filing chart, Emily. I mean, the final action date in EB2 is in 2009, September 2009. Everybody has filed it. I mean, so if we think so that the filing dates are not going to move, I mean, they're not going to move backward or forward, but does it mean the USCIS will allow us to file in November or will not?
That would be the question of the month, and I would love to know the answer to that right now because my life would be a lot easier if we know that we have more time to file these applications. All we can look at is history, and we've only had this dual chart system for 5 years. It goes back to October 2015. The two other times that we've been allowed to use this filing date chart in October, we were also allowed to use it in November and December, and one of those years we even were able to use it in January.
Oops,
January 2019.
I'm
we were
not
able
aware
to
of
use
that,
it.
Emily.
Yeah. So
wait.
whenever we've been allowed to use it in October, we've also been allowed to use it in November and December, and one time in January. So that tells me, I think, We have good chances of being able to use it in November, but it does really depend on how many people file in October. But given the current economy and all of that, I think that maybe the filings are going to be lower, taking people longer to get prepared to file because of all the documentation. People are trying to decide whether they should do the downgrade, whether it's worth it or not. People are hearing about rejections of downgrades.
Oh yeah, let's get to the rejection topic, Emily. A lot of people are telling that, I had a TV session on Sunday, and then there are a lot of people who come complaining about their lawyers. Their lawyers are refusing to file as an amendment. And I said, that doesn't look a nice idea to file an amendment. What's your feeling?
Yeah, I don't think we should be filing as an amendment.
Well, my thing is going to get rejected in the mailroom.
I find this whole topic really interesting because these rumors have been flying since last week. I have yet to see one substantiated report. Not one. Not within the immigration lawyers community, not within employees that are being sponsored. Not one person has come forward to say, here's the rejection I got.
Here is the rejection
one.
I got.
I really think this is fake news. Because on top of that, we started filing October 1st, right? If someone was able to get a downgrade prepared in 5 days and file it in October 1st, more power to them. Those checks, those filing fee checks, are just now starting to get cashed. There's no way.
I saw the September 23rd one getting cashed.
Exactly, just today.
Today, I saw September 23rd that we filed, Emily.
Right. There's no way someone would have gotten a rejection notice last week on a case that was filed as a downgrade under the October Visa Bulletin. I just don't think it's possible.
I have not spoken with a single person because I do conduct conference calls every single day. About 100 people come in, and I do conduct the TV sessions every Sunday, and we do conduct it. I haven't yet, my case, got back to the office. Here is the evidence, but if somebody has got it, we really want you to contact us in email, but we will do a free consultation for you just for us we can gain the knowledge. I haven't received it. Now, assuming even if they do though, I don't think so that you should file your I-140 in a wrong way. The right way of filing is to file a new application. Amendment is actually changing the original structure. Do we file amendments for the I-140s? Yes, we do. Especially when there is a corporate changes, when there is a tax ID number and the name of the corporate changes, and there is a successor of interest. That means there is a new company that has been formed and that has taken the responsibility. We do file an amendment at that point of time. There's no doubt we do file it. But I don't think so that filing a amendment in a normal circumstances is the right way of filing it. And based on the discussion that I had with good clients who are not ours, their lawyers are in complete agreement with us. In fact, they're not filing it as an amendment. They're filing as a new application.
Yeah, and also remember, this concept of downgrading is not new. We've been doing it for years. Many times successful in doing this in other categories when it benefited the client.
I have to yet see a denial from the downgrade. I'm not saying that we won't get it, a denial. We haven't been. I want you to watch the videos that we've done in 2018 and 2019. You go to YouTube and search with our name, and you will see the downgrading thing that we have presented as a headline topic in 2018, in 2019, and actually about 3 months ago, me and my other business partner, Mr. Ryan, we just presented a 10 minutes thing just only on downgrade, nothing else. So we want you to look into those things. Downgrading is not new. We used to do mostly for Chinese nationals, not so much for the Indian nationals. Because for Chinese nationals, things move back and forth, and we have done so many times, never had any much difficulty. Obviously, when I want you to watch the 2 weeks before video that we presented about the ability to pay. That's one thing that you may want to be concerned about, especially if you're not working for the company. That's one drawback if you're not working for the company or downgrading that I want you to be aware of. Lots of questions that I want to address, some of the main things that are coming in Facebook and YouTube. Is there a premium processing for a advanced parole and EAD application? The answer is no, there is none. Is there a premium processing for the adjustment of status on 485? The answer is no, none is available right now.
Question from YouTube, Ramakrishna, how long will it take to get the receipt notice for the 485? I would expect at least 3 to 4 weeks because there is going to be a rush of filing in October, and as I've said, we've not received any receipt notices for cases filed in October yet. We're just now seeing checks cashed for cases that were filed at the end of September, so it's going to be another week before we start getting those. So 3 to 4 weeks at least to get 485 receipts from October.
Rahul has this question, is it possible to do day trading on H1B? It has to be on a different person to manage it. If you are trading stocks, even if it's on a daily basis, not like 100 times a day or something like that, but if you have a job and you're just trading stocks, that is not considered as a job. If you are managing the portfolio of other person, and you're trading stocks, it will definitely be considered as a violation of H1B because most probably your H1B does not allow you to do that. And unless you are you're on H1B as a trader, then it's a different issue. But otherwise, you are definitely violating the H1 status if you are managing other people's portfolios. But if it's yours and your wife's and your kids, kid under 21, I don't see that as a problem at all.
Adyan from YouTube says, some attorneys are saying it may take 1 to 2 years to actually get the green card, even if the priority date is current. Can you explain the reasons? I do think that's very possible. I mean, processing times are horrible.
It's 1 to 2 years? No, the processing time is 36 months.
Right, exactly.
So whoever said that 1 to 2 years, we disagree with them. We say that it's going to be 3 years is a processing time right now. If you go online, you go to USCIS, you go to processing time. Yes, they tell you 12 months to 36 months. You believe those 12 months to 36 months? It's always 36 months. It takes a long time for you once if the priority date becomes current. So all these applications that we are filing right now is only to get into the foot entry and allow you to file an E8 in advance parole. Not that immediately you're going to get a green card. It's going to be a long way before you get the green card, even if the final action date becomes current. The first condition is that the final action date has to become current. Once the final action date becomes current, then your processing time, which is 36 months, has to become current. At that point of time, then only you will be eligible to get the adjustment of status. And you will be interviewed in the adjustment of status. Mostly, there is a chance that they may waive you, but most often they will interview. And everybody who files an adjustment of status will get an RFE for one or the other reason. One reason is if you file the medical expires in 2 years. If you don't file the medical, they will ask you for medicals. That's a guaranteed RFE. I mean, that's how the things are. Previously to 2017, the medicals never used to expire, so there was never an RFE. There was not a need for you to go to the adjustment of status interview. But right now, from March of 2017, the medical expires in 2 years, and you most probably will be called for an interview at a local district office where you need to go there.
Krishna from YouTube says they missed the deadline for filing the H4 extension for their dependents, and they ended up being out of status for 17 days. Eventually, they left the country, got H4 visa stamps, and came back and are properly maintaining H4 status now. Want to know if these 17 days are going to be an issue for the green card I-485 filing. So assuming that you're filing your green card under the employment-based category, there's a specific provision called 245K that's meant for this exact situation. As long as you were not out of status for more than 180 days, they're still eligible for the green card. So it sounds like they should be fine, but certainly if I don't have all of the facts of the situation, make sure your attorney who's handling that is aware so they can properly complete the application.
A question coming from YouTube is, my lawyer is telling to only declare the income in the 944 and not declare the assets. Is that going to cause any problem in getting the adjustment of status approved? I don't see anything wrong in what the lawyer is doing, though. Do you?
Yeah, I don't think it's mandatory for you to provide your assets. I think it's the whole purpose of this is to prove you're self-sufficient, and your income alone should be enough if you're a high-skilled immigrant being sponsored for employment.
I would say the lawyer is a clever lawyer, then me. One person is telling, I received my green card before my priority date is current. Oops, this comes from YouTube. I want you to contact the USCIS and make sure that they correct their mistake. The reason is that you don't want to live that mistake, and 2 years down the line, they come and say, well, we'll revoke the green card. Then you lose the H-1B, you lose everything, you lose the EAD. I have gone back to the USCIS, I've corrected the system, and they were able to get that thing canceled and make my client stay on EAD. Because what will happen is that 2 years down the line, they find it, and that will be a huge mistake. And then when you go for the citizenship, that's where the whole thing rings up, and there is no way to cure. Believe me, I have a client that I've been fighting for 8 years right now, and I cannot cure that because they did an error in granting the green card to that particular person in that year. And they won't give that lady the citizenship right now. They say, and they threaten, oh, we will cancel your green card now because it was wrongly issued. What will happen to her? I mean, it's a big problem for her. I've been fighting for 8 years with no good results.
Neeraj from YouTube wants to know if the preliminary injunction was filed just for the wage increase interim rule, or also the specialty occupation rule that's going to be going into effect soon. So this was just fighting the DOL regulation. The specialty occupation regulation is a DHS regulation, and I've not seen any litigation filed on that yet, but I do expect it to be coming.
Yeah, one thing is it has to become effective, Emily, because for court litigation, normally the court may not entertain unless it's become effective. What if the USCIS wants to withdraw it before it becomes effective? So there's a lot of weakness. So if I'm a lawyer, I'll wait until it becomes effective and then file a court litigation on it. This is one of the main topics, Emily. And it is very sensitive topics to a lot of people. And this is raised by Ajay Mishra. H4 aging out kids, are they protected by 485 filing?
Great question. And it all depends, because the Child Status Protection Act calculates the child's age only once the final action date becomes current, not the filing date chart. So just because you're allowed to file the 485 right now, if the child is under 21 already at the time of filing, or if you subtract the time the I-140 was pending and it makes them under 21 right now, you can file that 485 for them. But it could ultimately be denied if the final action date doesn't become current soon enough and they actually age out. So that's something you have to think through very carefully to decide whether it's worth it to file the 485 and hope that the timing works out.
I think so. To Ajay, it probably is worth for him to file it. You may be risking losing the money that you pay to the lawyer and the legal fees and the filing fees, though. One thing is that your kid should not get married to this adjustment of status until the final action date becomes current. And to understand the definition of marriage, what I meant here, I want you to go back to the 2 weeks video me and Emily has released, and I want you to understand what that marriage is. We don't want the kid to be married to the adjustment of status application until the final action date becomes current.
Jitendra from YouTube wants to know if the EAD and AP can be filed in November, even if the dates go backwards. So assuming you file just the 485 in October and then the dates retrogress, can you still file the EAD and AP? Yes. The benefit of the EAD and AP is simply based on the fact that you have a pending 485. Whether the priority date is current or not is irrelevant. So just as long as you have a 485 pending, you're eligible for the EAD and AP.
Srivatsala has, any advantage of filing 485J when EB1 final action date, any advantage of filing 485J? Srivatsava, for the applicants that are filing adjustment of status based on an I-140 which is already approved, it is a must that you must have the 485J application. For the people who are filing the 485 or adjustment of status application along with the I-140, it's not mandatory for them to file the 485J. It's not necessary at all for them to file the 485J at all. They can file just with I-140 and 485 together. They don't need 485. They don't need 485J.
Bharat Ramesh from YouTube wants to know the change of status from L2 to H4 for his son was filed recently. How do you mention that on the 485 for the current status? Yes, we have a lot of people in that situation where they have a pending I-539 because of the processing times are horrible. So either you're waiting for your H4 extension to be approved or your L2 extension to be approved or even a change of status to H4 or L2. And now you need to file your 485. So we simply provide all the documentation, provide that receipt notice, and then we normally will write extension pending or change of status pending in that section that asks about the current status. You'll always get an RFE at some point asking for the approval notice, or you can provide it at the time of the interview.
Questions about the consulates are popping up very much. The US consulates have issued notification that expect to be on a long waiting period for you to get the visa appointments. Their visa appointments are very, very limited. Even in cases of emergency situations, it is backlogged very much according to the statement. So anybody who is going for stamping though, you may want to be very careful how long it's going to take. Even if you have an appointment, there is a good chance that they will cancel that appointment and request you to reschedule the appointments though. As of now, we haven't seen much problems for the people who are eligible in Dropbox. Remember that Dropbox is only available in India, and there are some limitations to which when you would be eligible for the Dropbox. If you're eligible to Dropbox, you may have a good chance, but if not, going for stamping right now is a very disastrous thing.
Rakesh from Facebook wants to know if we file the new I-140 to downgrade, what happens to the EB2 I-140? Is it still valid? That's the whole reason why we don't file it as an amendment. We don't want to amend the EB2 to EB3. We want to file a second I-140 to request EB3 classification. That way your EB2 I-140 remains intact, and if EB2 ends up becoming current first, you can go back to EB2 if you've not gotten married to your EB3 case by using the EAD or AP. If you've continued to maintain your underlying non-immigrant status, then to take advantage of the EB2, you simply file another 485 using your EB2 I-140 approval notice.
This has a very interesting question, Emily. I need your attention on it. It's a technical question. The visa spillovers that happened starting from October 1st of 2020, where we got more extra green cards of approximately 100,000 extra green cards. If they don't, and we said the processing time is 36 months.
Yeah, I know. What happens to those visas if we don't use them up? I think that is one of the major reasons why the dates moved so far forward and why we're allowed to use the filing dates chart, is so that we can get all of these applications in at the very beginning of the fiscal year, and USCIS can somehow try to approve them all by the end of the fiscal year. They do have some sort of capability to apply a visa number to a specific file, even if they can't get it approved within the time. It's all inner workings of USCIS. Do you think they're going to go to waste? I've not seen that happen.
Yeah, I mean, in this year they did waste a lot of, and last year they did, I'm expecting they did wasted some good number of them. They haven't released the numbers yet though. Yeah, it's definitely there is a chance that they may be wasted, Emily. And if this administration is going to be back, they will intentionally drag it. Remember that they don't want these extra green cards to be given to the employment-based green cards. It just happens. The law is written in such a way they couldn't help it. It's not that the Trump administration granted it for us. It just came into, they hit somebody else and then we got a profit of that. So yeah, they may intentionally delay it to waste it. There's a chance for it.
Yeah. Jay from YouTube says, lots of people mention to maintain both the H-1B and EAD to avoid any status issues, even though you're getting an advanced parole. What are our thoughts on that? Yeah, especially if you're doing a downgrade, that is what we're recommending, because once you use the EAD or the advanced parole, you become married to that EB-3 filing. It's much more difficult to go back to EB-2 if EB-2 ends up being current first. A lot of people go ahead and get the EAD and AP, but really just have it kind of in your back pocket to use as a last resort. A lot of people do prefer to continue to extend the H1 or extend the L1 status, because if you don't, and then your 485 ultimately gets denied for some reason, that denial puts you immediately out of status if you don't have the underlying H-1B status. You begin to accrue unlawful presence immediately, and under the September 11th NTA memo, if you don't leave the country within 30 days, they can issue a notice to appear in deportation proceedings. So for all of those reasons, a lot of people do like to have that security of continuing the non-immigrant status even though you have an EAD and AP.
Visu from YouTube has this question. Once we file the adjustment of status, when can I leave the current employer? There is first condition, Visu, is that the minimum time period is 180 days after you file the adjustment of status. Second is that you must find another employer with a similar job, and you must file a thing called I-485J supplement. These two are absolutely essential for you to move job through adjustment of status though. Now, whether you receive the EAD or whether you don't receive an EAD is a different issue. If you receive an EAD and then you move after 1 month, it has nothing to do with the timing of the EAD. It has to do with when you file the adjustment of status though. Having said that, even though this is not a legal condition, I will put this as a practical conditions to all the people who are listening to me. I want you to wait. If you're downgrading, I want you to wait until the I-140 is approved, and I want you to wait until it's 180 days after the I-140 is approved.
Why 180 days after the I-140 is approved?
First thing is, they may be fine living after the I-140 is approved and the adjustment of status has been filed for more than 180 days. Is it required to have 180 days after the I-140 is approved? No, it may not be, but I think so it's more safer.
So at that point, they already have the priority date locked in from the previous I-140, so they're not at risk of losing the earlier priority date by porting too early.
I may agree with you, but I still stand my ground that I would like the people to get the I-140 approved and wait for 180 days. I'm definitely not telling you wrong. It's a good scenario, but I still want the people to wait. That's my personal opinion. Nothing substantiated in the law a lot of people ask the question, can we do premium processing on the downgrade? We do not recommend premium processing downgrade when you're filing it though. We have had a lot of bad experiences where our applications, entire applications got rejected though. We want you to file in the normal processing. Then you can convert once you get a receipt notice in the I-140 into premium processing.
Siva from YouTube has a pending 485 form and wants to know what's going on with the premium processing for the H4 and EAD. Yes, that is something that was included in the legislation that also increased the premium processing fees that took effect yesterday. However, the H4 premium processing, the EAD premium processing, expanding premium processing to these other categories was left as an option set by Congress, but USCIS has to actually implement it through the regulatory process. So it's not going to help you on your current application that's pending. They have to go through the regulatory process, decide what the cost is going to be, what the timeline is going to be, and then they will allow premium for that in the future. But I don't think it will help you for this current application.
Emily, what's your experience? This question comes from Siddharth Yadav from YouTube. What is your experience in filing the perm applications using the alternative wage surveys?
So, I mean, all of that gets determined way before the perm application is actually filed. The very first step typically is submitting the prevailing wage request. And yeah, we have been able to use alternate wage surveys in the past for the prevailing wage request. You know, the processing time is exactly the same. It's about 4 to 5 months right now.
So let me understand this. The prevailing wage, you get it from the alternative sources, and then you still go to the Department of Labor to get the prevailing wage?
Yes, exactly.
Okay.
So that's submitted on your prevailing wage request form. You provide the data that supports that alternate wage survey and make sure it meets certain criteria. And if the Labor Department agrees, then they will issue your prevailing wage determination using your alternate source rather than their OFLC data center.
We have had recently, and we didn't have any problem also recently, even after the new regulations went into effect. We filed with the alternative wages and they have been accepted. The LCA was been approved. Now in the prevailing wage scenario, it takes a long time for you to get the prevailing wage, but LCA gets approved in 5 to 8 days. So we haven't had any problem. If the alternative wages meets the requirement of the DOL, we didn't have any problem in getting those things approved. Birth certificate. A lot of people have the questions of the birth certificate. Do we need to have a non-availability certificates and 2 affidavits to file the adjustment of status? Right now, just based on, it's tough to get a non-availability certificate. I want you to just file the application with the birth affidavits. Maybe if they issue an RFE, at that point of time, you can get the birth non-availability certificate, because to go to the Indian government, state governments and get a non-availability, it's very tough, very, very tough. In some in districts, and especially the state of Tamil Nadu, they don't issue non-availability certificates, period. I have bad experience with them. So I want you to file with the affidavits, and then there are other alternative evidence that you can collect it. You don't have to submit it right now. Collect it like Aadhaar card, your PAN card, and your birth certificate from your hospital. All these things are secondary evidence that you can provide that will meet the requirements.
Kranthi from YouTube, both him and his wife have approved I-140s in the EB2 category. He's going to proceed with downgrading his to EB3 and file the 485 now, and wants to know if her EB2 priority date becomes current, can we file the 485 again with him as the dependent on hers? You can do that if you continue to maintain your underlying non-immigrant status. So assuming you're both in H-1B status after filing this adjustment of status, you still need to continue to maintain your H-1B status and not use the EAD, not use the advanced parole, don't get married to the EB3 case, so that if her date later becomes current, you can both file the adjustment again based on her priority date.
Question that comes is that on the B2 visas, can we file an extension beyond 1 year? That means that they have filed an extension for the first, they came here and they filed an extension. So first it was 6 months and they filed an extension for 6 more months. Can they file one more extension when the first extension is still pending? We normally don't advise unless it's a medical things where people have medical emergencies. But right now the whole world is in medical emergency according to a lot of medical experts. I'm not speaking as a lawyer, but the CDC and certain other people are telling don't travel, don't do all those things. So yes, it is a medical emergency. You can apply for the second extension while the first extension is pending. But make sure that if when they leave the country though to go to their home country, they shouldn't come back in the next 2 years, because that will show that these people are trying to stay in United States and visiting India. So if they do stay because of the medical conditions that they have right now, not traveling it, make sure they don't come, once they go to India, whenever they leave, they don't come back for at least 1 to 2 years, they don't come back.
Rashmi from Facebook wants to know, after applying for an H-4 extension, considering processing times are over a year, what happens after the current H-4 expires? Is there a time limit? Is there a problem if it's even more than 180 days? As long as the H-4 extension is timely filed, meaning before the current H-4 expires, then that pending H-4 extension keeps you in a period of authorized stay the entire time it's pending, even if it takes a year. So you are lawfully allowed to remain in the country after your I-94 expires based on that pending extension the whole time it's pending, and then get the approval with the new I-94 a year from now.
The spouse and child are not present in the country. Can they file the adjustment of status in the future once they come into the United States? Yes, they can, but the priority date has to be able to, filing date has to be there. I mean, the USC, you remember the dates move forward and backward, backward. It used to be May 1st, 2010 for the EB2, in March of 2012. From that time to right now, it never crossed the May 1st of 2010. It took 8 years to cross that date. Now, when the priority date becomes like this, can I predict that the priority date is going to remain the same or go back? Well, let me tell you, Mr. Anant Kumar, no, my predictions always went, well, not always, but I would say that most often, 98% of the time, went wrong. So if the priority dates go backward though, then your spouse and kid cannot file the adjustment of status. Questions from Anusha Wundavalli. Can we file H-4 EAD while H-4 application is pending? Yes, Anusha. You don't have to wait for the H-4 to be approved. You can use the H-4 receipt notice to file the H-4 EAD. You don't have to wait. You don't have to wait for the approval of the H-4 application. Anything else, Emily?
I think that's about it for today. We've got to get back to our clients, get our cases filed before the end of the month. So thank you for joining us.
Thank you for joining us.
And good luck to everyone who's filing their downgrades and filing the adjustment of status this month. Hopefully we will have a new visa bulletin soon.
Thank you very much.